We're going to get to some questions, a Q&A section. Folks, there's still time to submit a question to our speakers. You can use the chat window. Once again, to see the chat window, you'll need to press the Launch Full Experience button and select the Q&A tab to type in your question. And we have a couple of questions here. But okay, gentlemen, we have some questions for you. What I'm going to do is I'm going to present a question specifically to a speaker. We're going to do it in the order of the presentations. And if someone else on the panel would be interested in weighing in and providing an answer to the question, feel free to do so. So we're going to start with you, Andrew Burns. Andy Burns, what sort of communications are sufficient to satisfy contractual notice provisions?
Well, I think that the question is really how formal does the communication need to be? My position, and there aren't hard and fast rules on this, but again, I think especially in a COVID situation, reasonableness is going to be the key. I would submit that the communication needs to be written. Verbal communications aren't going to cut it. After written communication or written notice is provided, you may then be able to establish some elements done verbally, but in general, I would never want to rely on a verbal communication as being sufficient notice. And then I think that form over substance is important. I think that, or actually, I'm sorry, it should be the other way around. You don't want form over substance. If a text or an email contains all the requisite information to put somebody on notice that an issue has arisen and is being investigated and potentially may lead to a claim and the need for a remedy, then I think probably courts would or arbitrators would be inclined to find that a timely notice has been provided. So I don't think that it has to be a letter, delivered snail mail, written by a lawyer, citing specific contract terms. I think that if a written communication between the two parties in an email contains all the requisite requirements and puts the party on notice that the issue has arisen, I think that's sufficient.
Thank you, Andy. Steve or Roger, would you like to add or amplify that response? Any ideas?
Well, my only issue would be if what the contract might say about it. I've written contracts where I required the notice to be by certified mail, return receipt requested, or I've required it to be by an overnight courier, or fax or email, or a combination of those. So you got to look at least to see if there's any kind of requirement for notice as written in the contract document, just because sometimes people, might prefer to have fax or email because of the instant nature of it, and they want to be notified of things right away.
Yeah, my only comment would be the ultimate question in matters of law, just like we were talking about, in order to have clarity and to push something towards settlement, rather than leave question marks that open the door to litigation, is not to build notice or timing according to the least common denominator. Don't worry about, is it enough? Worry about how good can I make it? How strong can I make it? How can I put enough detail and use in the proper form and method of transmission, like Steve mentioned, to eliminate any issue? It's not good enough. It's never good enough, like we were talking about, to go into court and win. Because if you do that, you're not really going to come out a winner. Make it so black and white that there's no real issue, and if necessary, so black and white that if it's litigated, you can prevail on summary judgment.
Thank you all. Let's go to a new question, and this one will go to Steve Noodleman. Steve, do force majeure clauses provide additional time or money to the contractor should a force majeure event arise?
The answer to that is it's going to depend on what's written in the contract. And I think as I've indicated, when we looked at the A201 standard provision that's in there right now, it only provides for the extension of time. But it does say after that there is nothing saying that you can't have another provision that provides for damages. And I've had contracts where parties have negotiated, particularly contractors who really want to make sure if there is for example, a material escalation, there's some increase in materials cost or something because of a supply chain problem, they want to be able to seek the difference. They don't want to have to bear the expense of that added cost, or if they have to work overtime because they had a labor shortage because there was a number of people who were sick. Again, the contractor doesn't want to bear that cost, and that's something that, you know, it might make it into the force majeure provision, or quite frankly, it might make it into a COVID provision.
Andy or Roger, do you want to say anything about the force majeure provisions, or should we move on to a different question?
No, the only thing I would add is going back to the nature of the contract. And if it is essentially a matter of materials prevailing over labor, or where the sale of goods is predominating purpose, that gets you into the provision of the UCC in Article 2, which, as we've discussed, sets in some way a lesser standard than impossibility and talks about impracticability as to an unforeseen circumstance. So it's always important, as you look at these issues, to step back and ask yourself, is there something not in the contract that maybe applies? And one of the possibilities could be Article 2 of the UCC.
Okay, let's do the next question. We'll direct it to Roger Bradley. And again, Andy and Steve, you can weigh in. Should I have my expert present at the mediation? Roger, what do you think?
Well, it's a real good question. I think the answer is going to depend on the particular circumstance of the case. You never like putting up your expert for grabs for a couple reasons. You don't want to give away your case, number one, and number two, you don't want your adversary to size up your expert or perhaps even know who it is until there's appropriate discovery, whether it's state or federal court. So I think you keep your expert close to your vest. But on the other hand, you could have your expert report lined up, and the attorney could, without disclosing that the comments he makes or she makes comes from the expert, present the expert A, facts, and B, graphics presented by the expert. I had this situation in a rather large case where the other side had their experts, because they had about 9 people from 2 major contractors, some of whom were experts, and present their case. We had our expert, who actually was the claims consultant on the World Trade Center, in my office. They never got to see him, never got to know who he was, but we were able to make a compelling presentation, not by bringing him, but by bringing his handiwork, which I presented, which left him free, if it didn't settle and you go to trial, to not be bound by something he said at a mediation, even though it's off the record. So I think there's a difference between presenting a witness as an expert and presenting the substance. And in a real complicated case, I would keep my expert close to my vest.
Andy, Steve, any thoughts on that? Experts present at a mediation?
Yeah, I have a unique displeasure to work in a state, Oregon, that does not have expert discovery in our state court system. In my mind, it's absolutely ridiculous. In doing construction work, usually the claims are complicated enough that they cannot be addressed without expert assistance. And so what we tend to do, and also because we're not a huge state and the construction bar tends to all know each other and we all know the experts, is we enter into agreements where we conduct expert discovery informally through cooperation. And so many times in our mediations, the experts will be present, because a lot of what goes into the mediation is discussion amongst the experts, sort of a mini expert meeting conducted while the mediation is occurring. And I've had many cases that have resolved because our expert was reasonable and so clearly more knowledgeable than the person that the plaintiffs brought, that basically the case ended up settling around solutions posed by my expert, because they were so clearly reasonable and knowledgeable. So it's a common occurrence for me in my state that the experts are very involved in the mediation process, but it's unique, I think, to the fact that we don't have expert discovery.
Sal, this is Roger. If I just elaborate real briefly, but so much depends on the facts of the case. When people are reasonable and want to resolve matters, sometimes you could do what we've done here. Both sides had, it involved a falling down of panels on a large building. Both sides had their experts, one from New York, one from Chicago. Actually, at the site, they walked around the project together, and they came up with a conclusion that actually allowed the parties to settle virtually immediately. On the other hand, when the parties are obstreperous, I think you reach a different result, and instead of finding a situation where the parties work together, you find parties that are going to be each other's throats, and maybe you might be giving away a little too much. So I think it depends on the factual scenario of the case, and is there a potential resolution reasonably at hand?
Yeah, you're definitely right about that. It does depend upon the parties and the facts of the case.